that was talking about a witness for the state, saying, in light of your statements, the arraigning, that any recording or broadcast may be a contempt of court. If I have knowledge of someone in the state of Minnesota who would be presumptively be under the jurisdiction of the state who violated that order, what would the proper course be? Should I bring that? Should I note that in the trial? And it actually, I need to verify my information before I actually do make an accusation. But I have reason to believe that someone in the state who is actually associated with the prosecution's case was the person that's doing that. So this statement, it's kind of fascinating, like I say. And I'm gonna read the documents that it's attached to. And then I'm going to work in, like I said, the revenge prawn thing we talked about the other day. And you have this, again, I'm responding, oh man, all of this is witness intimidation. I was like, really now? It makes you wonder about strategy, too. The discrediting of somebody court-wise, not just getting them in trouble. And again, if they are violating, they are violating. If they did do revenge prawn, they did do that. They definitely did this stuff live, by the way. So that is not a question of, did that really happen? Yeah, we did see that recorded. But let's look at the documents that this is attached to. Remember, there are 3 items that are actually going on in the courtrooms that involve Nick Rekieta. You have, of course, the state versus. On top of that, you have the matter associated with DHS, with the kids, and you also have the matter that is going on with Monograph. I forgot his name for just a second there. I was like, wait, what's his name again? Oh yeah, with Monograph. This is actually much clearer than we typically get with these type of documents. It is still, if it is a little fuzzy, that is on the document side. It is not on our side, but we have quite a few pages for this. Again, this is transcript of proceeding. This was uploaded. These aren't uploaded to the site itself. Somebody is going, it looks like they're photographing themselves. That's why they look exactly how they are. But let's check this out. So appearances. The petitioner appeared through its attorney. They give who the attorneys are. That would be the county's attorney's office. So again, that's why they're it. The mom, she makes appearance. That would be Kayla, along with her attorney. So, there had been question. I think this is also something that helps answer a question. There had been questions about representation. What exactly is going on there? Well, you have documentation of representation here for Kayla's attorney. And then you have Nick appearing along with his attorney. Now, along with that, you have the child. This would be the oldest child. I redacted name. Now, the name, of course, has been out there a while, but I'm trying to scrub names because, again, we're talking about kid names here. So the child, it'd be the oldest child. They appeared. Now, the guardian ad litem, they appeared. Also present, Alicia Sweep. Now, Sweep, infamously was named in a live stream. I don't think there's been any naming since then, which is smart, which is, the way that should go. You shouldn't be naming these people or talking about them in any way, shape, or form whatsoever. They were brought up, I think, in an angry portion of a stream once. That kind of stuck with me because I was like, but recently there hasn't been any naming of them as far as I know. Social worker, through, again, County Health and Human Resources, foster parents, and paternal grandparents. I'm just going to read the minutes here. That way it includes everything, So whereupon the following proceedings were duly had. The court. We're going to go on record this afternoon for an emergency protective care hearing. This is in the matter of welfare of children of, so that again, Kayla Rekeita. They don't know how to pronounce the name, so they go over that. Talk about, here, represented by, so they give representation. The guardian ad litem. They also appear. They tell you, Alicia Sweep is also in the courtroom. Again, so the record should reflect that the oldest child, too, was also there. They're like, yeah, I am here. That's what's redacted there. That's, if you see some really terrible white boxing, that's me. Give me a second here. But in addition, at least I understand it, in the courtroom today are, give me 1 second, both paternal grandparents. They tell you, that the kid that's present is one of 5 kids, but the only one present in the courtroom. As I mentioned, the matter is set for emergency protective court, a care hearing. It's my understanding the children were placed in protective care following the execution of a search warrant. There's reason to read this again. There's the part that's mentioned that hits Aaron here. So I thought it was interesting that it works its way into this. And the arrest leading to an order, and then leading to today's hearing. It's my understanding that we will use the preliminary springboard, if you will, for the next hearing, which will be a combined admit deny emergency protective care hearing. And I say that because there's an advisory to protect all children who are age 10 and under, and redacted that would be the oldest child again, or redacted them, has 2 other siblings who are at least age 10 and are eligible for McKenna Advisory, which does a couple of things. One, it gives them the rights to have an attorney appointed for them, and 2, their right to go to court and be present at court hearings. So, and that's interesting, isn't it? Your kids too, depending on age, that they have the right, number 1, again, to have an attorney appointed for them, and to 2, the right to go to court and be present at court hearings. So the court will delay not until all 3 eligible children are present. I wasn't certain from the petition, which I heard, so let me ask the parents, are any of the 5 children eligible for membership? Native American, of course, they ask about that. Recognized as, if they are or not, so that it's brought up, because that, again, brings them under the Indian Child Welfare Act. I just thought that was fascinating, how many people think that's not a real thing. I think as a parent, anything that involves kids hits you kind of where you live. Here's the fascinating thing with Aaron. At the beginning, everybody was like, oh man. Well, I won't say everybody, but a lot of people were like, oh man, this guy, just coming out. And it's interesting to look at commentary with Aaron and to see how a lot of that's changed. As more and more as things went along, how if you look at the commentary on his own channel or on clip channels, definitely changed over time. So they talk about they had an admit deny for everything that came up. Again, I just want you to see what comes up in this conversation, because this all, it's just like I said, it's fascinating. So there's objection. Is there any objection? No. All right, Ms. Weber, are there any objections to the court granting a continuance with the notion that remain in the out-of-home placement pending hearings? No objection. We're just asking, we got the kids that are older. Should there be access to parents? Certainly like Zoom and phone calls. So they were talking about access to parents. Again, like I said, there are a couple of things in this that are fascinating outside of that. Also, I would like to indicate that the petition drafted by the county itself indicates that the children were in no knowledge of any drugs being in the home and are not aware of any use. Any testing of the children that would result in drug use, according to the children, would be because of secondary exposure from some other source. So this is actually a fascinating statement there. There were discussions over whether or not kids knew. Okay, well, the state itself, according to this, in their own drafts, are saying that the children had no knowledge of substances that were being utilized in the home, and that any testing that came up, any results, that wouldn't be from, the reason I'm saying it this way is because there were people that were saying, well, maybe this happened or maybe that happened. Maybe substances were given to kids, due to the high level of in testing. Remember I think the levels were like over 5,000 with the cutoff at 500. So, you were talking about high levels there. And this itself is saying, well, any testing there, that would be from secondary exposure. I understand the county's position is trying to attempt to facilitate the safest visitation for the children, but there is no indication other than simply a statute that these children have ever been in danger of exposure to any substances, or that their parents have been under the influence of any substances around them or while providing care. So, Your Honor, I would just ask that the very minimum, we go ahead and go with initial suggestion that the maternal grandparents who are currently providing care be offered the visit, or be allowed to facilitate supervision and visitation. We've not done anything to not cooperate with the county, other than to assert our rights to request counsel before seeing, before answering any questions, and before submitting to any testing. It's something that we had not had any, give me 1 minute, opportunity to do, giving, again. So what they're saying with this is, as far as refusal to cooperate, like again, this is interesting because the refusal to cooperate notion being presented, they're saying, well, we were trying to make sure that we actually protected our rights. That's what all of that was about. It wasn't about, refusing to do anything. It was about counsel. Like I said, certain things in here like that, they make this, like I said, we just got a hold of this. The first time they spoke to county workers that are home today, despite multiple attempts over the weekend, they starting at 8 a.m. to contact county workers. I was unable to, until they arrived at our home. When they arrived at our home, they found a home that was much cleaner than what was initially found. Now, this statement was actually brought up. I thought this was interesting where people were discussing it. They were like, we've been making immediate efforts now that the school year is finished to go ahead and take care of the clutter in the home. So, when this was brought up, you were like, hey, the house was indeed cluttered. Yeah. You also want to appear to be very cooperative. Like in everything you say, I'm cooperating. I'm cooperating with X. I'm cooperating with Y. For sure. But that was something that was pointed out. Hey, wait a minute. There was clutter. So we're not even requesting that the children be placed in our home during this continuance, but merely that visitation be supervised by people who are obviously qualified to provide the supervision and are sitting in the right room, or in this room right over there. It's over 3 decades in this county. So they're like, hey, they're going to be right there. They know exactly what's going on. So, yeah. So the court, they ask. And Rekieta, they ask him, in this county? Yeah, that's right. So the court, it's like, Miss Sweep, what's the agency's timetable to getting through the vetting process, providing education material to supervisors? I would say we would look to doing a safety meeting. Of course, that's normal. Within depending on, so again, the dates on this, you see the dates on it. But again, this all just came up. And it's just fascinating to see where it's been going. Cooperation of the parents within the next week or two. Okay, that's longer than I anticipated. Why can't it be done this week? The court's like, hey, why can't we get this done quickly? Because again, remember, all of this was based on an emergency. So they came in, they were like, hey, due to this, we need something done with the kids right now. And that only holds for X amount of time. So like, hey, something needs to be going in place. So it's a very active investigation, told that is early in its stages in regard to the agency learning, who's had knowledge of use and drugs in the home, who's been notified of use of drugs in the home, and the education behind how to look for use and being under the influence. All right, so they get their dates on the admit deny, which we've heard about. Now the court will grant parents' requests for continuance, given their prima facie showing for the petition that it would protect the rights of both parents to continue the matter. It provides the parties additional time for safety meetings, safety planning, of course, all of that. The court takes notice that the holiday weekend puts this at a standstill since the arrest. The court will also find that the agency was unable and has demonstrated by the petition that given the particular circumstances of the children's removal from the home, there were no services or efforts, just give me a second, there were no services available which would have allowed the children to stay in the home at that time. In particular, both of the parents were arrested. This out-of-home placement or emergency out-of-home placement was indeed necessary. They had to have something there because, again, look at the circumstances. Currently, the proposed out-of-home placement with the children's paternal grandparents is the least restrictive and most home-like, and certainly meets the cultural needs of the children. We've talked about that. Everything that you do is supposed to defer to the safety of the kids, but also, again, it's supposed to look at their needs. So when we look at that, again, it's noting everything that we've talked about before. That's the way the court's supposed to look at it. That's actually the way that DHS is supposed to look at it too. Meets all needs. I would push this matter a bit harder because I take a personal view that the harmony Visitation center or visitation at the agency is artificial at best, not appropriate for older children. If you have a 2 or 3 year old, that works pretty well with toys. Older children, it does not. For now, I will utilize that as supervised visitation, but ask the agency to come up with a safety plan. Again, this is all about how they establish. I mean, again, it's everything that we figured happens, but we didn't see. Or alternatives, if not, some of the family can agree upon some safety planning. And then we'll continue. Again, they give the date, when. At that point, children will have attorney available for them. The judge will provide mechanic advisory. If there's anything else for the record, this is where we're going to get over to that. This is when it starts to pop up here. Anything I've forgotten? There's one other item for the mother and father's perspective, Your Honor, likely just a typo. On the other thing I wanted to say on the record, I've been given information as to Zoom use, the arraignment on Friday. That was immediately ignored, and we were published immediately. So the default in these cases will be in person, since we've not done well with the use of Zoom. Ms. Weber speaks. It brings up the thought. The judge is our judge next week. Is he going to be here? We're going to have to go to him. I'm very concerned about some of the folks, given my client what he does for a living. These are people that I think are going to continue to try to disrupt these proceedings if the judge is by Zoom. That actually, you saw what happened. It's actually a damn shame in its own way that when you have a meeting, I mean, you saw, there was somebody that was basically saying, again, I'm paraphrasing, but hey, what, you off yourself, stuff like that. And yet they did end up muting that after a moment, but that's one of the reasons that you end up switched to the current setting. It's like, hey, folks out there, you can't handle yourself enough. Oh, like I said, that's a damn shame. It's at a point, well, taken, we're working through that. I can tell that neither the court or court administration had any idea what was coming at them right up until the time of the hearing. So again, they were like, yeah, it was pretty wild. And it was, by the way. Do you think that everybody kind of got a taste of that? We know there's some folks that are just, Cheryl, you're kind of the gatekeeper, for example. like read that. And then it just drops there. Well, there's some folks out there that are what? That are what again? What are you trying to say? We have to keep Mary up for the hearing. Yeah, I guess my suggestion would be that if the judge is there, that no one else be allowed in by Zoom, because they would need special permission by the court. So it would be here in person. Okay. Then, again, Mr. Rekeita is going to speak down here. That's my thought as well. If sometimes I'm scheduled, Baker County, 20 minutes later, 15 minutes later, I'm scheduled in Swift, so the judge can be via Zoom. Everyone else can be in the court, That might be something different. They know there could be different reasons. And then you have Rekeita. He's like, Your Honor, in light of what you had to say about this, in your statement in my arraignment that any recording or broadcasting may be in contempt of court, if I have knowledge of someone who would be presumptively be under the jurisdiction of the state who violated that order, what would be the proper course? So again, Mr. Rekeita is asking this. Should I bring that by, give me a second. Should I bring that by motion in my criminal trial to you? Should I bring this to Miss Pierce? I mean, what should I do in this? I want to verify my information before I actually do make an accusation. But I have reason to believe that someone in this state who is actually associated with the prosecution's case. Again, that's Aaron. 100%. And it's fascinating because here's the thing with this. The association with the prosecution's case from there. I'm wondering, like I've been saying, I get the feeling from a lot of stuff that I'm seeing that one of those sources that they spoke to, we had our 4 anonymous sources. We don't know who they are. Yeah, this other person that's associated with that was one of the people who broadcast that hearing illegally. So again, they have to be a live streamer. They have to be associated with the prosecution's case. You know exactly who that is. Like I said, that doesn't leave a lot of leeway there. You know, it sounds like Aaron was up there talking to the prosecution. He's associated with that. It's like, that's kind of fascinating, because that wording, that again leads me to believe, who is one of those sources? Oh yeah, I bet you. If this plays out, if it does go to fighting there, yeah. And I'd like to make sure that this is brought to the attention of the court, and Your Honor specifically. Now, the court said I won't be assigned to the criminal case. My involvement is probably done. Having an arraignment, Ms. Pierce, that information your agency or your office would want. Like, Your Honor, we do not want that information directly. It could potentially bring us accelerate action or make us a witness. I hear the kids talking back and forth. We direct all information too. You can either provide it to law enforcement or to the assigned judge. So they're like, hey, you know, that might put us in a weird place. You know, if you bring that to us, that might cause, again, somebody they've been talking to, that might make us, again, that might put us in a weird position. That's what it sounds like they're saying. It's like, okay. So he's like, all right. If I verify my findings, I'll raise it with Judge Fisher. Thank you. So, you know, they go through that. Okay. Now, again, I thought, like I said, this part, I wasn't even going to cover this. You know, that's why it took me 2 days to even bring this part of it up at all. Because I was like, you know, I saw people bring up the cleanliness of the house portion. And I was like, okay, well, I guess that is, that could be cooperation. That could be anything. I thought the statement on the children and on substance use, you know, with the state itself writing up that, again, they were stating, you know, this would be a secondary issue. I thought that was something that it should possibly at least be noted, because the state itself is reportedly stating it that way. And again, I'm not saying that, I'm just saying that for clarification, you know, because there were a lot of, well, what ifs? What if? Well, the state wasn't saying that. The state was saying this is caused by secondary exposure. That's what their allegation was.